Welcome to another episode of the Wealth Multiplier Podcast. Today, I'm joined by Krista Simon, a 20-year lawyer and partner at Hammerco Lawyers. She leads the team in the Estate Litigation Division there. I won't take all of her thunder, and I'll let her tell you a little bit more about her accomplishments along the way, and then we'll get into it. Krista, welcome.
Thank you so much. First of all, kudos to you for providing this opportunity for the public to receive some really important information about wealth preservation in this manner. I just think this is terrific. So thanks for providing me with an opportunity to speak on my area of expertise. As you said, I've been practicing for 20 plus years now. Most of that time I've spent at Hammerco Lawyers. My legal education, my background, I went to Dalhousie Law School. I have a Master's of Law from Osgoode Hall Law School, where I focused on dispute resolution and adjudication. I've done some enhanced mediation training at Harvard Law School and Pepperdine Law School. And so I've really focused on not only practicing as a lawyer, but understanding opportunities for my clients. In my estate litigation practice, I work with 4 other colleagues. Most of us are working out of our Vancouver office, but also we have an office in Courtenay on Vancouver Island, where we're a little bit more local for clients there. Hammerco's clients are all across the province, though. All across the country, and in fact, we have clients all over the world. U.S., South America, Europe. It's just so easy for us to communicate and to advocate for people who are out of country these days. Our focus is on dispute resolution and problem solving. So my philosophy and my approach is really to protect what is rightfully yours. Clients come to us with a dispute, with questions, wanting to challenge the validity of a will or an estate plan. Clients also come to us, as we sort of say, as innocent bystanders. They are named as defendants in a dispute. They are a family friend who is named as an executor who now has to navigate their way through a dispute. So we're really focused on problem solving. We're solutions oriented, and we try to be really efficient in our strategies.
Okay. And then just for everyone who doesn't exactly know estate litigation, so in the estate world, obviously we would highly suggest that you make your plans up front. And then where does litigation versus planning, like what's the difference there?
Yeah, absolutely. So we don't do any planning.
So no writing the will.
No drafting of wills, no creating trusts. Firstly, my first piece of advice today for anybody who's watching is have a plan. Communicate with your family, whether that's your spouse, your children, your parents. Communicate, talk about what the family assets are, what individual assets are, and what people's expectations are. Have a lawyer, have an accountant, have an insurance professional, have a financial advisor, and encourage all those people to talk to each other. So that's the first part of it. Have a plan, but that's not something I can help you with, except to encourage you to have relationships with professionals. Estate litigation is on the other side. It's where there is a problem, where there's a dispute, where there is a challenge. Something is not turning out how somebody or some group of beneficiaries had expected it. It's where there is a challenge to set aside the will, where there is a challenge to rebalance the will. So it's completely on the opposite end of planning.
And then as people come to you with the disputes, whether they're on the offense or on the defense, what's in the 80-20 kind of world, what's the 80% of stuff that comes to you? What are the big mistakes that you see all the time that could have easily been resolved and never come in front of you?
Yeah. I think there's 2 parts to your question, because you're asking me about mistakes that I see being made. Not all disputes arise out of mistakes being made because people are challenging estate plans even on the face of them. They appear to be reasonable. In terms of mistakes, I would say the biggest mistakes come in not planning and then not communicating the plan. So there are some mismatches between the plan and beneficiaries' expectations. Then there's the mistake of not updating the plan. You can't just sit back and say, I have a plan from 1999, because life changes, circumstances change. I think another mistake that people make is that they do not really think through the consequences of their actions. And so, people enter into relationships not thinking that the relationships are developing into something that becomes formal under the law.
Right.
Moved my girlfriend in, but we're not really common law because we've, kept so many things separate. Or they haven't thought about the consequences of designating a beneficiary on a registered investment, or not designating a beneficiary, or not changing a beneficiary. So, I think those are the main mistakes. And then just a lack of communication that can develop over time. And not recognizing that relationships and families change. Some children are closer with parents than others. Caregivers start to become close to our elders, and our family members are becoming more reliant on them. That's sort of mistakes. In terms of the 80-20 of what are the most common disputes that we see, they probably fall under three main categories. Okay. One would be challenging the validity of the will, to say, look, this will should be torn up, tossed in the fireplace, because either there are some formalities that are missing, there's no will, is this really their signature, something is missing. There may be undue influence, meaning the will maker was coerced or forced into making a will that they really didn't want to, or that they didn't have the requisite capacity. And we're seeing that more and more as our elderly family members are starting to experience cognitive decline, whether or not there is a formal diagnosis of dementia. So that's dispute number one, or challenge number one, is let's toss it out. Challenge number two often comes with joint ownership of property. So out of convenience, and this can be a really great planning tool, people are often adding children or others to the titles of their property, or adding them to bank accounts. If that is not documented properly, then that can be challenged, and assets that may on the face of them fall outside of the estate, there could be a challenge to bring them back in, to say, look, you weren't actually the beneficial owner, this was a resulting or constructive trust, let's add it back in to the estate and everybody can share. The third main dispute are wills variation claims. And that is where everyone acknowledges this is a valid will. We understand the assets that are in the will, but the will as written is unfair. And so we don't want to toss it out. We just want to rebalance it. So it could be that someone is entirely left out of the will. It could be that there is an unequal distribution of the will. And for wills variation claims, there are some very strict restrictions. These challenges can only be brought by spouses or children, natural-born or adopted children, and these claims must be brought within 180 days of the grant of probate.
Okay, so within 6 months.
180 days.
180.
It's not always at 6 months, 180 days.
All right.
Yeah.
That was a lot to unpack there.
Yeah.
We'll start at the beginning. You were talking about one of the big mistakes that people have is not communicating and not properly setting expectations. So I think regardless if we're talking about wills or we're talking about anything, generally in life, it's good to communicate well and it's good to have your expectations set. What are some things that you've seen people do well And so for like a practical thing of how would I communicate or how would I set those expectations? Do people say have like a family meeting, or do you talk about it at the dinner table, or everybody comes to sign the will at the same time? Like, what are some things that work?
I would say the latter is a no. Any planning lawyer will say, I want to meet with a person on their own and ensure that, they're not being influenced. So really it's dinner table conversations, it's formal family meetings. Sometimes it's sort of off the cuff. On the other hand, there are some people that are incredibly private about their financial circumstances. And good reason for that, because, the sharks start circling. I think from a parent's perspective, some parents don't want to set up too high expectations to demotivate their children from working hard through their lifetime.
Right.
I think the most important thing is to communicate that there is a plan and the rationale behind the plan. So if everyone is getting an equal share, communicating that and explaining why. If there is someone who's getting a little bit of an extra share, again, communicating why. Share and share alike is not always fair. If you've got 3 children, for instance, one is very successful, has worked hard, is educated, owns a business, everything's good. Another child who never really received a formal education and sort of bounced from job to job to job, experiences financial insecurity. And then you've got another person who throughout their life was successful by objective measures, but then becomes ill and is not able to work as much. Well, an equal plan might not be fair given the circumstances of all of these individuals. And that's where a wills variation claim can come in. But again, just communicating so that if somebody is getting a bit extra, at least the other children will understand that.
Okay.
The courts do respect the independence of the will maker to make their will and make decisions. So that means that a will that is equal in any circumstances could be found valid.
Right.
But an unequal will can also be found to be valid, and vice versa. It's really all over the map.
So there's no set way that it's going to happen.
There really isn't. And that's why when people come to me and they are either defending a claim or even if they're bringing a claim, it's really important that I get full disclosure from them. When I'm working with clients, it really is a collaboration. It's kind of, this sounds silly, but I say it's a Jerry Maguire moment, help me, help you.
Right.
Provide me with the documents. Tell me all about your family history. Don't hold back. I want to hear the good, the bad, so that I can weigh it all out. Because sometimes I have to say to clients, I'm not sure if it's worth this challenge.
Right.
Or I think it's worthwhile trying to compromise. These things can get dragged out. It can really impact families and family relationships in a negative way. And sometimes it's not this generation that you want to preserve the relationships. Maybe the siblings say we're done with each other, but don't forget there's cousins. There's another generation that may still wish to have a relationship. So, I'm kind of one of those lawyers that takes a bit of a holistic approach. What are your goals? Here's some options, and let's talk about the implications. If we go really hard, here's what the fallout could be. Here's the cost-benefit analysis. If we, are softer and try to compromise early on, what's the implication there? And then, all the options in the middle.
Right. It's there was a Warren Buffett quote about how much he's leaving to his kids, and obviously very rich person. And he said, I'm going to leave them enough so that they can do whatever they want, but I'm not going to leave them enough so that they can do nothing. And then, and also he also then says, so in the will, how do you communicate with, or he says, he's very active saying you should communicate with your kids about what's going on, because he goes, if I write the will now and I talk to them about it, I can answer questions. If I write the will now and I don't show it to them until I die, I can't answer any questions. I can't tell them why or what is going on. Obviously, his life is very public as well, and there's probably a lot of information out there. I like what you were saying about thinking of the consequences on, hey, we might be able to win this, but we'll press really hard. But if you win, do you really lose, right? Like, is there ever going to be a Christmas dinner again? Like, will you ever be able to invite those people to your house? Or will you ever be invited again? So does the money or the asset or the house or the car or the jewelry or whatever it is it worth it to really push on that fight? Really interesting. You were talking about when there's kind of three big categories of when people would come to you. So whether you just throw out the will completely. And so can you talk maybe a little bit more about, you were saying some reasons of talking about it wasn't written properly, there might have been influence, or they might just not have capacity, like they might just not know what they're doing. What's an example of, say, maybe somebody having undue influence on that? So say, brothers, sisters, cousins, caregivers, who can exert that influence, and then how would I know that they're doing that, and how would you protect against that before it becomes a problem?
It's so complicated. One of the complicating factors, I think, is that we don't all live close to our aging parents.
Right.
And especially for people who grew up in smaller centers and then are moving to bigger centers in the same province. But, if you grew up in Vancouver and you're living in Toronto now, you don't see what's happening with your parents day to day. So as parents age, they become more vulnerable. I would say that the most vulnerable person is an aging parent who's now on their own. So their spouse has passed. So your mom or dad has, one of them has passed, and you've got one remaining parent. And nobody lives close by. And so there is a trusted caregiver. Or there are multiple kids and one lives close by, and that person has the opportunity to influence the parent if they're a bad actor with bad intentions. There are so many family members, there are so many caregivers who are wonderful and who are actually supportive of our elders. I think the first clue is isolation. And so, if someone is really planning to take advantage, they will slowly, carefully isolate the elder from their family. They're not available for phone calls. It's not a good time. They're out, they're napping, so less and less. And then they're taking them to their doctors. They have a relationship with the banker. And some of these people are really, they put on really great acts. I think there are other people who actually exert undue influence, perhaps, and they've fooled themselves into thinking they are really being very helpful, and so they deserve more, and they, deserve to be on the bank accounts, and they deserve to have the freedom to make all of the decisions.
Right.
So I think the number one thing to look out for is the isolation, and just making sure we're checking in with our elderly parents and visiting them, and making sure as many people as possible have relationships with them.
Right.
One of the things that I also see as our parents age is that they want to avoid conflict. So sometimes elders create expectations that are not correct because they don't want to be honest with you.
They don't say no.
They don't say no, or they don't tell you, I have changed the will and I've not favored you as much as you had expected. And so to you, they're making promises. To you, they're making promises. And at the end, everybody's really surprised at what this will has to say.
Wow. Yeah.
So there's a lot of human factors here. I'm a lawyer. I'm not a psychologist or a social worker. But what I do observe in my work is that, there are layers and layers of complicating factors. And some of these fact patterns are really nuanced.
Right. So it sounds like be in communication, stay on top, pay attention. And then maybe even when outside people are involved, have some sort of guardrail system set up, or have some sort of have boundaries, and hold those boundaries, right? Which is a healthy way to live, right? In all relationships, whether you think there's going to be an abusive or potential for abuse or not. Okay. The other reasons that you were saying out of the three would be, say, like an uneven distribution, or somebody was expecting and didn't get. What are some ways that people could, that this uneven distribution happens, and then maybe what people would expect and not get? I know in our practice, we've had situations where, there's multiple children, some of the children doing really well, other children maybe not doing so well. There may be addiction issues. There may be really bad financial management issues. They might also have abusive people in their lives that are exerting influence and trying to get more, or trying to say, well, you should. How can people how can they protect against that kind of stuff so it doesn't end up with you?
Yeah, I mean, I think I'll leave the specifics to a planner. Let's put it that way. Let me offer my perspective as a litigator. Somebody comes to me and says, I'm a bit of the black sheep of the family. I've had a more troubled life. Maybe it's through no fault of their own. As you say, addictions issues, or they've made life choices that their parents don't agree with in terms of sexual orientation, right, or conversion to a different religion, or sometimes it's as simple as, I had a baby when I was a teenager, or I didn't go to university when my parents wanted me to. We'll say the black sheep for whatever reason. But again, through no fault of their own, they come and they say, look, I'm left out completely. And there might be a note in the will. So the planners have done the best they can to justify in the will why Sammy or Jenny, has been left out or gets just 5%, whereas everybody, the other two siblings share in the 95%. Again, my advice to them is, look, you have a legitimate claim. Estrangement from a family, if it is through no fault of the child, should not result in them being treated unfairly under a will, generally speaking. And there's a number of cases on point, and I don't invoke the word cases to get really technical and legal, but just to share that the law is one thing. The WESA, the Wills, Estate Succession Act, says that a will can be varied where the will maker has not made just, adequate, and equitable provision. What does that mean? You say, well, that's legal jargon. What does that mean? Well, I think it is purposefully subjective, broad, and ambiguous, so that the cases and the way these cases resolve can reflect our societal values. So the black sheep of the family, I say, should have a share in. And the will maker might have good intentions, might say, you have a terrible spouse. You can't manage your money to save your life.
Right.
You've got addictions issues. But you know what? That's not their decision to make. Because at any time, this outlier child can have a change in their circumstances. They can get help and they're healthy. They leave that relationship. They meet a great financial planner who can help them protect their money from anybody who might swoop in. So the court will say, look, you may have had good intentions, will maker, but you haven't made just, adequate, or equitable provision. And so, yes, we will rebalance it. Most of these cases don't go to court. I guess I should have said that a bit earlier on, because a lot of people are intimidated or they are hesitant to consult with a lawyer because litigation means trial, means going to court, means it has to be costly. We have to be aggressive.
Public.
And, the reality is it could be no further from that. Most of our cases, although we do sometimes have to take advantage of the different steps in the litigation process in terms of formal document exchange, examinations under oath, we also settle most of these cases because it's in the best interests of everybody.
Right.
Because I think at the end of the day, people sort of look at all the circumstances and go, okay, I encourage my clients to make what I call a personal business decision. Let's do that cost-benefit analysis. And a mediation is a great opportunity for parties to get together with the assistance of a neutral facilitator in a private and confidential setting and kind of hash it out. And a dispute that might otherwise go on for more years can be resolved in 8 or 10 hours.
Right.
And there's finality. And most of the time, we do agree to whether it's a broad or a limited confidentiality agreement so that, after it's done, everybody gets their distribution, gets their money. No one should be talking about it after that.
We're done. Yeah. I like how you were saying cases and mediations, because that just implies that whatever you are going through or whatever might happen has happened before to other people and solutions have been found. So a lot of times in these things, obviously, it really depends on your personal situation and on your family situation, but you probably also don't need to reinvent this wheel that's been invented a whole bunch of times before you. And by opening up and going to somebody like you do this every day, you can say, well, I've seen this exact situation 50 times and this is what's happened in the past and this might work for you.
Yeah, absolutely. You got it. You've been listening.
Right, it's
Yeah. And, we sometimes can do some very swift settlements. Sometimes people come to us and say, actually, as much as we have a dispute and we have a problem with the will, we actually all want to resolve this. And can you just help us? And it's really just about figuring out, well, what do you want to do? Because oftentimes siblings do get along and they want to be fair to each other and they want to continue their relationships. And they say, you know what, maybe mom and dad had really good intentions by doing this, but we don't think it's fair. Here's what we think is fair. All you need is for everybody to have their own lawyer. Everybody needs independent legal advice. Then one lawyer can draft up an agreement, can pass it along to the other lawyers. Sometimes there's some tweaking that's involved. And then everybody signs off.
right. You either agree or you don't, or you make changes.
Exactly. Or the circumstances are just so obvious that, okay, this is going to be an easy challenge in law. Again, let's make sure everybody has a lawyer. When everybody's represented, frankly, things can go really smoothly because the lawyers understand the law. They also understand where we can push the boundaries and create, right, this fact pattern is a little bit different. And so we think maybe there's opportunity for a little bit of a tweak in the result. Okay, fine and fair enough. I like to think litigators are really creative thinkers as well. But oftentimes, getting the lawyers on board, getting things documented, getting them signed, and everybody just goes their separate ways and they carry on.
Cool. The third thing that you were talking about, why a lot of people come to you, is because maybe somebody's name has been put on a house or somebody's name's been put on an investment account or bank account or something like that. And the other children or the other people involved are not on it. And maybe this person thought they were getting it. This person thought they were not getting it. This person, how can that be avoided up front? Does it help to document these things? What are some things that should be in those documents so that they don't end up coming to you?
Yeah. So whenever you're going to add a child or somebody else to your property, I suggest you see a lawyer about that so that they can give you some advice on what the implications are of what you're doing. There are tax implications. They might send you to your accountant. But in terms of the law, it's best to document this. If it is intended as a gift, then there is a legal tool called a deed of gift. It communicates your intention that this person is a true owner. I intend them, and I didn't mean for them to contribute in any way. Because otherwise, it gets very fuzzy.
Right.
There are lots of different reasons why a parent, for instance, would add their child to title. Tax efficiencies, estate planning, just for ease of dealing with bills.
Right.
You know, when they're older, maybe it's a rental property and they want the child to be taking care of or maintaining that property. So there's lots of different reasons why someone would be on a title, but really they're legal but not beneficial owner.
Right. And then what does that mean, legal but not beneficial? And what's the difference there?
Mm-hmm.
And what kind of clarifications would you have to make to say, okay, you're allowed to touch the property, but it's not yours, or it is yours, and you're...
Yeah. So there's two parts to ownership. It's the legal ownership and it's the beneficial ownership. And I would say most of the time, people who are the legal owners of a property are the beneficial owners, meaning they're meant to take the benefit of it. They will contribute to it if there's any growth in the value, if there's any rents. The legal and beneficial owner captures all of that. There are some times when people's name is on the title, but they are not meant to be a true owner. They're like a trustee. They're holding the property for the benefit of somebody else, perhaps the other joint owner. Again, documentation. If you're adding somebody to title, if you're buying a property with somebody and they have not contributed and you do not intend for them to be the beneficial owner, then you've got to document that appropriately. And again, I suggest you go to a lawyer to do that.
And you'd probably want to talk about this and to the other members of the family who may also think that they're going to somehow inherit this house or this bank account or this business or vacation property or whatever it's going to be.
And sometimes that's quite upsetting. There is, among some people, an attitude of entitlement. I am entitled to inherit from my parents. I think that's okay. That's really normal. But don't forget that your parents can do whatever they like with their property during their lifetime. Mm-hmm. They can sell their property. They can add other people to title. It's their property.
Right.
Upon passing, their estate will be subject to their will, or if there is no will abide by WESA with respect to an intestacy. But, your parents can do whatever they like. I think most parents are adverse, though, to having those uncomfortable conversations with some of their children. And that's why I say a lot of these problems, the root is communication. I understand, though, why it's hard to have conversations at certain points in time.
Yeah, definitely. And setting those expectations clearly and not trying to say yes to everybody. And then at the end of the day, that's how you make people unhappy. You think they're making them happy, but really it causes bigger problems later. If you would have just been candid up front, nicely, you don't have to be a dick. You can nicely tell people your wishes and stand by them, hold those boundaries. We deal a lot with people's financial plans, right? So we're not putting people on the title of their house and stuff. That would be up to other professionals. Where do you see people making mistakes or people really doing it right in terms of, say, investment accounts, maybe life insurance, financial plans, even succession on a business? What are some best practices so that people don't end up in front of you? And then also some, if somebody does need to come and challenge or to defend, what are some things that they can do to make sure that they have a good case?
Again, I'm not a planner.
Right.
So I'll offer my perspective in broad strokes.
Yes.
I think I'll go back to sort of what I said earlier, which was have a plan. Keep the plan updated as things are changing. Again, you can't just make a will and then sit back.
Right.
Because circumstances change so much. You may have other children. You may have another spouse. You may end up with a blended family. You may actually experience business losses. Unfortunately, some people are a little bit more aggressive with their investments, and sometimes they are different than they were at an earlier point in time, or they have to use the money. So I think all I will say is I will direct people to a really great solicitor who's going to do your estate plan and who's going to work with a financial advisor that can advise you of all kinds of different tools. People's estates are very, very different. If you are fortunate enough to have built some wealth such that registered investments, insurance policies, trusts, corporations are a part of your plan, then you've got a lot of different options available to you. But I will tell you that a lot of the disputes actually arise out of people who seem to have very simple estates, one house. Because remember, that house that was bought in Richmond in 1969 for $10,000 is now worth $3 million. And so, an estate plan that was workable in the 90s probably isn't that workable now. And don't forget, people are living longer. We have had instances where there's a will, that's great. It, maybe it distributes everything equally to all of the children. And then the will maker lives to be 100 or 105. Right. And some of their children may have passed by then. Their estate has changed. Maybe some of the children have moved back in with them. It gets very, very complicated. But at a certain point, that person probably lost the capacity to revise their plan. And so you're stuck with a very, very, very old will and an old plan. And so I want to go back to your question, what can people do? Continue to look at your plan every 3 years.
Right.
Is your will still valid? Do you want to make tweaks and changes? Looking at your financial plan, looking at, what investments you have and insurance policies you have. I think, again, it's just keeping it on your radar. And for heaven's sakes, if you have a plan and you've seen your lawyer and all you have left to do is sign it, don't leave it in your inbox for months and months, because something might happen and you never get to execute on that plan, and you may be stuck with a plan that you knew was obviously wrong and you intended to revoke it.
Right.
So it's not just about planning, reviewing and revising, making a new plan. It's actually executing the plan. It's actually designating the beneficiaries, switching the beneficiary designation, as circumstances change.
Yeah, we've that's happened a few times. Just a recent story as well with somebody who had an insurance policy, exactly like you said, sitting in their inbox, waiting for a signature. Took a couple months to sign, but during that period of time had a massive motorcycle accident. And without having signed the insurance, so there was no insurance. And then now this is like it's a really bad situation. Or changing beneficiaries, so having a divorce but not updating your paperwork, and then the ex-wife or husband is still on everything, and then something happens and the new people that are involved can't do anything about it because all of the paperwork still says the old people that are involved, right? And then, but I like what you're saying about updating every 3 years. I think that's a really good rule of thumb. Some other things as well, like if something changes with property, you buy a house, you sell a house, somebody new moves in, or different relationship changes, so new spouse, somebody moves in, somebody moves out, somebody's the best friend, somebody's not the best friend. Those are all good triggers to go back and look at the plan and say, do I still want it to be that way? Or...
Life is really complicated, and you and I have talked before about some of those really extreme examples of where, there was a second family, a second secret family, or, there were children from a previous relationship, people reforming relationships with them in secret. There are so many complicating factors to life, and as much as you're communicating and you're planning, there are just some circumstances that nobody sees coming. And once the will maker has passed, they don't have to deal with any of it. It's those who are left behind who have to sort of pick up the pieces, especially when there are unexpected families and spouses and challenges.
A really interesting estate litigation case, actually here homegrown in BC, with a motorcycle rider who had a couple of different families. Do you want to maybe talk about how that can affect, and now that that case is settled and we can actually talk about it as public, how that can affect the estates going forward? Because there were a lot of moving parts in this one.
Yeah. So I know the case you're talking about. I will say I don't know if it has settled, but that issue has been resolved with the court. And essentially, the case was brought forward by a woman who was seeking to be considered a spouse under WESA, the Wills, Estate Succession Act, because her partner died without a will. And under WESA, when you die without a will, there is sort of a format that you follow. The spouse has a preferential share, and then if there are children, then there's an outline of what share they get as well. I guess the wrinkle in this case is that this woman wasn't the only spouse that the deceased had.
Right.
In fact, he had been living a double life. He had a wife. He was legally married, and he had a wife on the mainland, and they had 2 children. And some years later, he started a relationship with a woman on Vancouver Island, and they also had children. Now, I think we'll say spouse number 1 and spouse number 2. Spouse number 2 knew about spouse number 1. But it seemed like a tired old story that there were promises made that he was leaving his wife and he would, be full-time with his second family, but that never happened. He passed away unexpectedly. And so the court decision was all about whether 2 spouses can be recognized under WESA. Because WESA holds the definition of a spouse to be someone with whom you are living for 2 years in a marriage-like relationship. And he was going back and forth and spending extended periods of time with both families. And ultimately, at the end of the day, the court found that, yes, WESA does contemplate a situation for purposes of inheritance that there can be 2 spouses. I think it's an unfortunate situation for both of these women and also their children. It's quite a shock, I would expect, to have this publicly aired. It was all over the news. And that's why I say I don't know if it's settled. This element was settled. And so now it was really left for these 2 spouses and their children to determine how the estate could be divided up, given that they both had some preferential entitlements and then would be sharing with all of the children. So I think I say we as the royal we've got to be careful about being mindful of the consequences of our actions, which is something that I had mentioned earlier, sort of one of the mistakes that people make. Firstly, this person, this will, he wasn't even a will maker, this intestate deceased, didn't have any plan. Knowing that he had 2 families,
Right.
He still had no plan. And unfortunately, it was left for these 2 women to publicly kind of pick up the pieces. Some people ask, well, isn't this the court legitimizing polygamy?
Right.
And that was addressed. And the judge said, no, this isn't a family law matter. And WESA seems to leave open the opportunity that people have 2 marriage-like relationships at the same time or at some points in time overlapping, and leaving aside the question of whether this was polygamy, because there was a legal marriage and then there was a marriage-like relationship that was recognized by WESA. Whether or not that would be a common law marriage for purposes of family law, that question was not addressed or answered.
I said that's up to them to decide.
That's right.
And then another case that we actually talked about before this, where they were in a marriage-like relationship, and then they weren't, and then they were, and then they weren't. And do you want to talk about that? There was like two women.
Yeah. So this was a sad case, in fact. There were two spouses in a relationship, and a reasonably long-term relationship. They were not legally married. They were in a common law relationship, which of course is a legal marriage, but I want to make that distinction.
Right.
Because it's important for the WESA analysis that they were in a common law relationship. They had some challenges because the deceased, toward the end of her life in particular, had some mental health issues and was sort of erratic in some decision-making. One of the important things as well, which is a complicating factor, is that for cultural reasons, the deceased had not disclosed her same-sex relationship to her family, who primarily lived out of country. And so I suppose it was a shocker when the deceased passed, and then it came to light that she had at some point had a spouse, a same-sex spouse. And so it was the family of the deceased who was actually pushing in this application. The deceased died without a will, so it was another intestacy like the other case. And the application was all about whether the spouse was indeed a spouse, because it was an all or nothing. If she was a spouse, there were no children. She would inherit 100%
Right.
of the deceased estate. If she was not a spouse, then the estate would go to the family and whoever was remaining, either parents or siblings. The wrinkle in all of this is during some of the ups and downs, the spouses entered into a formal separation agreement.
Right.
Which, by all accounts, we're encouraging people to document things and to plan and to protect your assets. So that was very smart. The document ultimately was found to be a financial separation rather than a dissolution of their relationship. This is actually a really interesting point, because if they were legally married, the separation agreement would have been a separation,
A total
per
separation.
per WESA. Because they were in a common law relationship, the analysis under WESA is a bit different. And so while this was a financial separation, the judge found that it was not a formal separation for purposes of WESA. And so at the time of the deceased's death, notwithstanding the financial separation, they were still in a relationship. There was no separation. And so the remaining spouse was indeed found to be a spouse.
Yeah. Get your will written. If you have one, make sure it's updated. Talk to your parents. Make sure they have a will written. And if they have one, make sure it's updated. Talk to your parents. Talk to your kids. Talk to your brothers and sisters. Generally, communicate, set expectations to help you in all aspects of life, not just in your estate plan. So you've been a practicing lawyer now for more than 20 years, 21 years, and partner, first female partner at the firm. We have a lot of lawyer clients, actually. In the categorization of jobs of our clients, lawyers is actually the number one. What would you say to a young lawyer a couple years in from the bar, coming up now? Like what kind of advice that you would say, these were the best times, these were the worst times, try to do this, try to avoid that?
Oh, there's so many things. But to keep it simple, I would say, first of all, stay true to yourself. Be yourself as much as possible, and don't try to be smaller than you are. Let your preparation speak for itself. Let your knowledge, let your demeanor, and your respect for others speak for yourself. Speak for itself. I think what you put out, you get back. There's no question that over the years, people have tried to kick my tires and to use their seniority to their advantage. But again, just taking a breath, knowing that I was always prepared really allowed me to be confident in situations that I might have otherwise felt intimidated.
Right.
Lawyers should not be cookie cutter. We should be different. Our clients are different. They look different. They sound different. We all have different interests. Over the years, my practice has seemed to attract a lot of women. I love acting for everybody and anybody, but it seems whatever I'm putting out there really resonates with women, and that feels great to me because my clients are reflective of who I am, and that makes for a great working relationship. I have always tried to be generous with my time and my knowledge. It's why I've always been very committed to always offering a complimentary consultation. So pretty much anybody can get 30 minutes of my time, as long as it's within my field of practice and experience, just so that we can talk through the issues. And I believe that knowledge is power, and I really want potential clients and just community members to be able to make informed decisions right from the get-go. Do I want to even work with a lawyer? I want to inform them so that they can make a decision. And whether, sometimes I say to people after a consultation, you really need a lawyer. Now, I don't know if you feel we're the right fit, but you really need a lawyer. Legal fees are an issue for everyone, and we try to make that as accessible as possible. We've got some different models and fee structures, and I would encourage other lawyers to do the same. We can't offer, a contingency fee agreement for everyone on every case, but we'll certainly consider it. There are a lot of people we can't help for a number of different reasons. They're not on the right side of the law. Their case is not going to be successful.
Right.
I mean by that. Or maybe they don't have the budget. And that's unfortunate. It's heartbreaking. But if I can give people a little bit of information and treat them respectfully, I think, I've helped them a little bit.
Cool. And then before we go, how does somebody get in touch with you? Like, where do they find you? Why should they find you? Why should they not find you?
Yeah. Well, I think we've got a great website.
And what's the website?
www.hammerco.ca. Okay. And you'll see I'm there in my profile because I think you want to know who you're consulting with. So make sure you're always looking up who's the lawyer. Right. What's their background, what's their training. We also have a lot of resources on our website, frequently asked questions, articles, updates on the law. I think that's great. I'm happy for people to email me directly. I'm not afraid to receive emails directly. We have a great client care coordinator, an intake coordinator, who will do a very brief interview, issue spot, request documents before a consultation. But, I stand by my offer of a complimentary consultation because I think it's really important in getting to know the professional you might be working with, and also issue spotting and identifying issues. Some people, you don't know what you don't know.
Right. Okay, awesome. Thank you. I think that's going to be a wrap for us today. If you did get value from this, make sure that you hit the like, make sure that you subscribe. If you want to leave a comment below, ask a question, or if you want to send a direct message or an email. And then definitely check out Krista and her team at hammerco.ca. They have a really nice website, actually. And that's it for us today. I will see you next time.